Hey, what's up, guys? So today we're going to be looking at a little bit more of Judge Neilson's rampage. Here we can see the judgment that he placed against 4 Canadians without a hearing, all because they requested verifiable proof of ownership of their debt from their creditors. Now, it's funny how in all industries, requiring proof of ownership before a transfer of funds is standard business practice, right? If you're going to buy a car, obviously you pull title, make sure you're not purchasing a stolen vehicle. If you're going to buy a house, you go down to land titles and make sure that the seller is on the land titles and has a right to sell that house. Even if you go to Walmart and you buy a bag of chips, you can't leave the Walmart without your receipt proving that you own the item that you just purchased. But as soon as you step into the realm of finance, apparently, according to Judge Neilson, requesting proof of ownership of an asset before you forward funds is an OPCA scheme and an abuse of the court process. So Judge Neilson has gone ahead and just assumed that none of the private lenders were real in this case, and didn't even allow them to have a settlement conference or a hearing where they could present all their evidence to prove that their private lender was indeed real and did have the funds to pay out the debt in full. Now, just to be very clear of how off the mark this whole situation is from the standard court process, let me just lay it out for everybody. So normally in a litigation process, what happens is the plaintiff would file and serve a statement of claim. Then the defendant would have 30 days to respond with a defense. Now, once the defense is filed and served, you schedule a settlement conference, which is an unofficial court date where the plaintiff and the defendant get to gather under the mediation of a judge and see if they can settle the dispute. If the settlement process is unsuccessful, well, then we would enter the discovery phase. This is where the plaintiff and the defendant would exchange documentation and evidence so they can really see what the reality of the situation is. They get to present evidence, and then after the discovery process, there would be an actual hearing where everybody gets a fair chance to present their evidence and their findings to an impartial, unbiased judge. At that point, the judge would go ahead and make their decision. Now, in this case, that couldn't be further from what happened. What happened here is the plaintiffs put in a statement of claim, the defendants responded with a defense, and then nobody even got a settlement conference. Judge Neilson stepped in here and just started issuing memorandums without addressing any of the evidence that either party had put together. He even did ex parte hearings with only the bank lawyers present, and none of the plaintiffs were even summoned. And then he put together these memorandums stating that the plaintiffs, the debtors, had to pay $10,000 to receive a fair hearing. And this is all before there was even a settlement conference. There was no discovery. Judge Neilson refused to look at any of the evidence that the debtors had put together that supported their claim that their creditors may no longer own their debts. And he just decided, screw the average Canadian person, and put judgments out in favor of the large financial institutions. And this is all while sidestepping the standard process for due process for the Canadians, without giving them a settlement conference, without allowing them to do discovery, and without giving them a fair hearing. Now, this raises very big red flags for the Canadian people. If your bank does not have to substantiate their claim to assets before they come and take money for them, what does that mean? Well, if we want to be honest about what that means, that essentially means that any creditor, any bank can lay claim to any asset and seize that asset without the need to substantiate or prove their claim in a court of law. So essentially, banks are just absolutely running rampant in the Canadian court system. They've got corrupt judges stripping the due process from the Canadian people. They state that any claim against a bank is an abuse of court process and require Canadians to pay $10,000 to receive due process in Canada. I mean, how absolutely ridiculous. This should have us up in arms and screaming at the top of our lungs to others how absolutely corrupt and unjust the system is, or if it's not the system, it's particular judges in positions of power who should not be allowed to remain there. Why is it that banks do not have to prove they own assets that they are seizing or collecting money for? If this had been any other entity other than a bank, there would be news headlines about fraud, but here we have Judge Neilson just trying to sweep everything under the rug. No, they don't have to prove they own it. You're a criminal for asking them to prove they own it, and now you owe them $10,000 plus $5,000 in security costs, and that's what you get for challenging the large financial institutions. There's obviously no reason for the banks to refuse to provide proof of ownership, or the judges here to back them on their stance that they don't have to prove they own assets they're attempting to collect money for, unless they don't own them and they're attempting to commit fraud. I mean, I don't understand why, if these creditors did in fact still maintain ownership of these debts they're attempting to collect on, well then why can't they just prove that? And the judges in the Canadian courts should back that stance 110%. To creditors, if you do indeed own this asset, well, just prove it to the private lenders. I mean, that's basic commerce. Nobody just forwards funds to people without doing any paperwork, without documenting the transaction. So the fact that this Judge Neilson is stating that, oh yeah, banks don't have to prove they own it, they just own it, and we just know that because they say so, it's just absolutely ridiculous. If this were a transparent, unbiased court, and the banks were acting in good faith, well, then they would just have an accountant check their ledgers, confirm the debt was owned, provide that documentation to the private lender so they can get paid out in full. But due to the fact that they are unable to do that, because most likely they don't own the debt and they did sell it a long time ago, they have to jump through all these hoops, take away due process, and definitely make sure that the courts do not require them to provide an affidavit from a chartered accountant that states that they still own it.